I'm William Deveneau. I'm an estate planning attorney. I practice in Vermont, Massachusetts, and New York. A question I get a lot is, I have a trust. Do I need a will? Yes, you do. There are two documents that serve two different purposes. The trust is a legal arrangement where you, a person, a grantor, takes property and puts it into a trust that's managed by a trustee for the benefit of beneficiaries. The trust document outlines how those assets within the trust are to be managed, distributed, and then sometimes there's other conditions and instructions on how to distribute the money. Sometimes it's over the course of different intervals of ages, etc. A lot of stuff like that. Trusts are commonly used for estate planning to avoid probate and provide for management of assets during somebody's lifetime and a smoother transition of assets to beneficiaries. A will deals with all of the things that are in your name alone at death that don't have a beneficiary form. When we pass away, we're no longer people, we are now an estate in the eyes of the law, which means everything has to go to probate because probate court needs to appoint somebody with the legal authority to actually distribute your estate and administer it. That's where a will comes in. The will controls the probate process. It provides instructions to the court and instructions to your executor on what you want done. So unlike a trust, the will does go through the probate process and it's not as smooth as using a trust. A trust, you pass away, all of a sudden you have a new successor trustee who takes over selling assets, gathering assets, distributing assets, whatever they need to do. With a will, you have to petition the court, open the probate, notice to creditors, filing inventories. It's a much longer process. There are some things that a will can do that a trust can. For example, the will can typically name guardians for your minor children. The will is the place that you would name guardians for your minor children to, someone to care for them in case you do die. You can also put other things in there, some miscellaneous stuff like funeral arrangements, handling of debts, stuff like that. Your will would still, although it would have that stuff, if you have a trust, you would still have a will, but the will would typically be a pour-over will. It would have some of that other language in it about guardians and things like that, but the will would say, don't distribute to these people, distribute to my trust to be dealt with. So anything that ends up in probate still will take longer, but it'll ultimately end up in the same place. Most importantly is if you're thinking about using a trust or a will, consult a good estate planning attorney that knows what they're doing and focuses on estate planning. Thank you.